Good morning, good evening, good afternoon, Earthlings. Here we go again. Now, today I'm going to read out the judge's judgments on each of the 33 articles. As you know, Harry won, as the media, the mainstream media, or legacy media, as Elon calls them, are suggesting Harry won 15 out of 33. It's not quite like that. As you will discover, I have spent the last 2.5 hours writing out each last paragraph, which is what the judge gives his judgment about an article. I haven't written out the rest of it, and as again, link in the description to the actual judgment. And it is worth a read, it really is, because, well, it's so sad. I mean, this is not a defamation case, right? This is Harry trying to prove that his phone was hacked. And in order to do that, he's had to stand up in court and say these stories about me are true. And they must have got it by voicemail. So I think that's largely a point that Harry and his lawyers and all his fans have missed. That when there are stories, for example, about how he had a lap dance or was caught snuggling up to another girl, which made Chelsea very, very angry, he's had to stand up in court and say, yes, all that definitely did happen. That is accurate information, and therefore they must have concluded that from... Did you just hear an explosion, Graham?
Yeah.
Yeah, I thought I did, but it's not inside our house. Anyway, that's beside the point, or someone's letting off Christmas fireworks. So he's actually, instead of in history, and he says this is his life's work, this is what he wants to achieve, these court cases. In 100 years, couple of 100 years, those stories may have gone down in history as maybe they happened, maybe they didn't, they were rumours, it was sources in a newspaper. They would have become part of legend, but now, thanks to his extremely ill-advised and expensive court case, making a big song and dance, they're now going to go down as fact. Facts that Harry was drunk, fact that Harry wanted to find out the identity, how dare someone take a picture of him in a Nazi swastika, whilst kissing another girl behind Chelsea's back. I mean, well, the Nazi uniform, we know that happened because we saw the photograph in the newspaper. But if you read this case, all of these allegations he's making about voicemail interception, you'll quickly see he's going, yep, ding, ding, that happened. Yep, ding, ding, that happened. Yep, I had that private conversation and all of that. So, I think he should have followed the advice of the palace in the first place and let it all go. Anyway, Article 1, the judge says, the claim in relation to this article cannot succeed in any event. Article 2, the claim in relation to this article cannot succeed in any event. Article 3, given the public nature of the venue and the limited content of the information in the article, it is doubtful that the Duke could establish a reasonable expectation of privacy in relation to it. His counsel made some rather wild and unparticularised allegations of blagging of information, but there is no invoice that relates to this event. In any event, again, the claim cannot succeed because the article was published 2 weeks before the Human Rights Act 1998, which made Article 8 of the Convention of Human Rights part of the law of England and Wales, he emphasises, come into effect. So, again, I wouldn't use Sherborne and his team. Now, I could be wrong about this, but didn't David Sherborne act for Johnny Depp in Johnny Depp's UK trial and he lost? Or have I got that wrong? I think, I should have Googled that before, but I've been so busy doing this. But I seem to recall... but I mean, for the judge to use language like that, as I pointed out on the live last night, his counsel made some rather wild and unparticularised allegations. Well, that's not something you want to hear a judge saying about your lawyer, is it? And that they couldn't rely on an Act of Parliament because it didn't exist at that time. I mean, did anyone do any research? As you'll see, probably not. And the fact he has to emphasise the law of England and Wales because he's already made other references to he has no jurisdiction over Spanish, South African or Californian law. Article 4. There is no evidence and no inherent likelihood that voicemail interception or unlawful information gathering were used in this case. Article 5. The Duke was eventually constrained to admit in cross-examination, and we laughed about this on the live last night. He being who he is, there are many ways in which information about him can enter the public domain. Now, isn't that something that a lot of people have been saying? Who is the leak, Harry? Is it voicemail? Is it your family leaking? There are many ways. Maybe if you're rude to a member of staff and treat them like shit, they're going to run to the newspapers, or at the very least run home in floods of tears and tell their mum, dad, brothers, sisters and loved ones who may go to the newspapers. So I'm glad that the judge said the Duke was eventually constrained to admit in cross-examination, he being who he is, there are many ways in which information about him can enter the public domain. And I hope, well, maybe this extremely ill-advised and expensive court case will all be worth it if it got him to understand that one thing. The Duke, nevertheless, still preferred the inference that this information would have been obtained by voicemail interception. Standing back, it seems to me most likely that this information was the sort of information that a 17-year-old boy, a 17-year-old keen sportsman, would be likely to share with his schoolmates, to whom some explanation of why he could no longer play rugby would be required, and that the information was divulged to a contact by a schoolmate. In the absence of any other evidence of unlawful information gathering proximate to the article, and given the nature of the private information, I consider it more likely than not that there was no unlawful means used to obtain this information. I mean, what was Sherborne thinking, even allowing him to put some of these points across? This will cost Harry dearly. Believe me, it will cost him dearly. Articles 6 and 7. In summary, taking Articles 6 and 7 together, I am persuaded that voicemail interception of some of the Duke's associates probably took place, though not of the Duke himself. And that there was other unlawful information gathering, which included call data. These would have disclosed some of the Duke's private phone calls and conversations. So put that one down as a win for Harry. Article 8. This does not explain how the Mirror, unlike all other newspaper reports, was able to say that the Duke was being teased about it by Prince William and his friends. Oh yeah, I remember this one. I don't even know anything about this article, but now everybody's going to know about it. Harry caught a kissing disease, apparently. I don't know anything about that. I mean, talk about advertising your own dirty laundry. It does look suspicious. However, communications between the Duke and his friends and family was not the private content that was pleaded. Only the fact of the illness itself, so there is no claim in respect of any unlawful information gathering relating to these communications in any event. So that would be a lose for Harry. Because some of them it's not clear if it's a win or a lose. Article 9. The claimants had no other persuasive argument as to why this information would have been obtained by unlawful information gathering, or why there was a reasonable expectation of privacy about it after the event. So I think that's a lose for Harry. The claimants had no other persuasive argument. Article 10. In my judgment, it is much more likely that the addition was made by Mr Murphy to add colour to the story that he supplied, or by a person unknown at the People, though no one has claimed a byline. It is inherently unlikely that Prince Charles would have left a voicemail for one of the leg books, though doubtless there was a conversation at some time seeking his approval. So again, I'm not sure if that is a win or a lose for Harry. And a lot of his judgments, it's as if he's phrased his words for use in the future, for a future purpose. Now, whether that would be costs hearing or for precedent law, I don't know. Article 11. There is no documentary material to suggest otherwise in support of the claim in relation to this article, and one does wonder what kind of judgment was exercised when claims are persuaded to trial in respect of articles of this kind. Oh, that's a burn for Sherborne's team. It does make one wonder what kind of judgment was exercised. I definitely wouldn't use that guy as a lawyer. Definitely not. Article 12. The claim in respect of this article is also hopeless. I think we can put that down as a lose for Harry. You're not going to get David Sherborne and his team reading all this out to you. You're not going to get the mainstream media picking through the juicy meat in this entire judgment. No, they'd rather give a statement, some grandiose statement from Harry about slaying dragons and getting burnt. There's plenty of burning in this. Mostly, he's either burnt himself or he's been burned by his own lawyers. Article 13. I am unable to see how that makes it more likely than not that the photographs taken or the content of the commentary on them were in misuse by MGN of the Duke's private information. The photographer was obviously not commissioned by MGN. So why did his legal team put it forward that it was? If there was evidence that it wasn't. Otherwise, the photographs would not have appeared in numerous newspapers. They were taken by a freelancer and offered to the Mirror, and Ms. Kerr appended a suitable commentary based on what she saw and what was already in the public domain. You naughty Ms. Kerr, giving you all free speech and an opinion, that is against the laws of Prince Harry, the Duke of Sussex. How dare you exercise your free right to opinion? Oh! And actually even more laughable that Sherborne's team thought it'd be okay to present that one. The quotation from the onlooker is very likely to have been the photographer, though Ms. Kerr could not positively remember that she did speak to him. Article 14. In my judgment, it is probable that this private information was obtained by voicemail interception of messages between the Duke and his brother or other associates. The people as in a publication, therefore probably had the Duke's mobile phone number by this time, at the latest. As I have already found, it is likely that it made use of it cautiously on occasions. I consider it unlikely, given the risks, that it was used routinely or indiscriminately in the way described by Mr. Evans for the targets on his back pocket list. Now, that suddenly occurred to me. I mean, did the royal family really keep the same mobile phone number all the time? Or did they in those days? Because I always rather assumed they'd change their phone number every week, like Princess Diana did. Because it's kind of asking for it, isn't it? And then also, be careful what you say on a telephone call. I mean, there's got to be you've got to kind of look at yourself to some degree and think, maybe I shouldn't have said that. Maybe I shouldn't have worn that swastika. Maybe I shouldn't have betrayed my girlfriend by receiving a lap dance or kissing another girl. Maybe I shouldn't have been a twat because it might come out in the public and then everybody will know I'm a twat. As I've said many times, if you don't want to be thought a twat, don't do twatty things when you think nobody is looking. Seems to me Harry's more angry that his bad behaviour has been publicised, which I hasten to add, actually made him really popular, the most popular member of the royal family. All these little whoopsies and stuff, people just, oh bless, that's just Harry. Whereas since he married Meghan, my God. Article 15. As detailed in the private investigator schedule, there is credible evidence of Mike Burr having conducted or organised flight blagging and telephone bill blagging in relation to Chelsea Davy on other occasions. It is evident that the Mirror journalists had obtained details of the Duke's flights. In my judgment, the story in this article, particularly the all-important confirmation of the identity of Chelsea Davy, was probably stood up by the Mirror by commissioning private investigators to blag flight information, credit card details or phone billing data to confirm that it was Miss Davy who had been in Argentina. That unlawful activity was, I find, specifically instructed from London, not undertaken at the whim of Mr Bear. Mr Harwood's attempt to explain how else Miss Davy's identity was confirmed was wholly unconvincing. It follows that, since MGN directed the unlawful activity, the tort is established. That would be a win for Harry. Article 16. What is evidence from this coverage is that once again the Mirror was able to be specific about flight arrangements. I reject Ms Kerr's explanation that the return to London could be calculated from a previous publication which did not refer to the Duke's visit being for 5 nights. The majority of the writing of the article focusing on the threat that Ms Davy posed to Mr Davy, that Chelsea's dad, posed to African wildlife was done by Mr Brow, as the draft demonstrates, and it appears that Ms Kerr was asked to add in a bit of romantic interest. Most of it appears to be lazy journalism, which I think is rather rude of Judge Fancourt to say. He uses that term quite a few times. Picking up pieces from previous articles, but it is evident that someone at the Mirror obtained flight details relating to the various parties' journeys to and from Bazaruto. I find that this was likely to have been done in England by a private investigator by unlawful means. There is, however, nothing to support a case that voicemail interception was used. So partial win, partial loss there for Harry. That's how I read that one. Articles 17 and 18. In my judgment, it is reasonably clear that billing call data relating to Chelsea Davy's mobile phone must have been obtained by MGN for the specific content identified to be added to Miss Kerr's draft. How exactly this was done and by whom is unclear, though Mr Hannah and Mr Wallace were both involved and it would have been instructed from London. I consider that it is also probable that voicemail interception was used, though there was no case advanced that the Duke's own phone was hacked on this occasion. So I'm not quite sure if that one's a win or a loss for Harry. I think it's a loss, but I don't know. You see what I mean? The judge is not that clear. He's not like guilty, innocent, guilt. It's just not that straightforward. Article 19, the swastika photo. Right, this is all about, a mate of his took a photograph of him wearing a Nazi uniform, and also he had a girl with him, which I think we could all probably guess that Chelsea wouldn't be happy. Most partners wouldn't be happy if they saw a photograph of their husband, boyfriend, wife, partner canoodling with somebody else. I think that's a pretty safe bet, actually. But the judge doesn't agree with me on that, really. Given what had already been put into the public domain, I do not consider that the Duke on the 6th of February 2005 had a reasonable expectation of privacy in relation to the additional point, if it was correct, that he had been ordered to keep a low profile. This was really implicit in the other details of the punishment which had been made public. I am also not persuaded that this information was obtained by unlawful information gathering. The efforts of those involved in preparing the article was on identifying who had betrayed the Duke by selling the photograph, not on the detail of the punishment. That was not his private information. So that's a loss for Harry, isn't it? Article 20. Other than that item of call data, the Duke relies only on the extent to which Ms Kerr and Mr Hughes are proved by documents to have made extensive use of private investigators involved in unlawful information gathering. However, in this case, the nature of the comments attributed to ex-colleagues of Mr Lowther Pinkerton are not at all suspicious and are very unlikely to be the product of unlawful information gathering. That would be a loss for Harry. Article 21. I reject the argument that the Duke had no reasonable expectation of privacy in relation to Miss Davy's plans to spend time with him on a gap year. His feelings about that, how often he was at that stage of their relationship, on the phone to Miss Davy, and what he told his brother about his feelings, these things are private by their nature, but particularly so given that the Duke and Ms Davy had in conducting their relationship in the glare of publicity. Any secrecy they could get was of great value to them. So that would be a win for Harry. Interesting enough, all the wins seem to involve Chelsea. It's almost like the judge felt sorry for Chelsea. I feel sorry for Chelsea, actually, having all this raked up again. Article 22. However, I do not consider that the Duke could have a reasonable expectation of privacy in relation to a matter of his ability to participate in fitness training and what other cadets thought of the fact that he had been excused part of it. Oh, Mr Justice Fancourt, you were appearing before the Duke of Sussex. You should always rule in his favour over everything. Nobody is allowed an opinion. No mere mortal who comes within contact with the Duke of Sussex himself has the right to free speech. You should know your place, Mr Justice Fancourt. The Duke will be very angry reading your words, I'm sure. Subject to any regulations imposed by Sandhurst, any of the cadets or officers would have been entitled to tell family or friends what they had seen. Mr Fancourt, you really are overstepping the line now in the law of the Duke of Sussex. Did David Sherborne or any of his team have a little word with Harry about, just because you're a member of the royal family doesn't actually mean you can walk on fucking water and lord it around over all of the other peasants? Guess not. If they were not, the confidentiality was imposed by Sandhurst and was for its benefit. There is no case advanced that the Duke had the benefit of that confidentiality arising from the terms of his service or otherwise, and how arrogant, if I may say so, of him to even think he did. Article 23. Although MGN denies it, the nature, length and content of private phone calls between the Duke and Ms Davy are self-evidently private in nature. The fact that it may be obvious that a girlfriend may be upset by a boyfriend enjoying a lap dance. You think, Mr Fancourt? You think that we couldn't all just draw that conclusion that the partner is probably highly pissed off seeing their partner having a lap dance, right? It does not mean that the detail of Ms Davy's actual reaction and communications to the Duke and their feelings about each other are not private. They are certainly not outweighed by freedom of expression given the unlawful way in which they were obtained. Now, I don't know how he's established, I haven't read the whole thing, how he established they were obtained. I mean, if any of us YouTubers or any of you guys in the comments get quite near the truth, quite near the bone, you guess lucky, are you going to find yourself up on a charge of unlawful information gathering, you naughty phone hackers, you stop it immediately. I mean, I think if Harry's going to snog another girl and stupidly get photographed and then his actual girlfriend sees it, I think it's a pretty safe and reasonable conclusion to come to. She's going to phone him up and say, what the fuck? Isn't she? So I don't know why the judge thinks that was definitely unlawful. I would have said it's stating the bleeding obvious. Anyway, that's probably the only point I differ with on Fancourt so far. Article 24. I conclude, in the absence of some plausible explanation, this article was obtained by voicemail interception of the Duke's or Ms Davies or their associates' telephones, and by obtaining phone data. It seems likely that whoever was charged with obtaining information about the Duke and Ms Davy at each of the 3 newspapers will have been active following this publication to see how the storyline developed over the following days and weeks. I mean, I know that there's a low standard of evidence in civil proceedings, but I mean, there was a crime committed. I don't know by who, and I don't know when, but I'm certain it happened. I'm sorry, Mr Fancourt, because I guess you will watch this. It's gonna have your name in the title and the tags, but I mean, for God's sake, officer, quick, a crime. Where? I don't know. By who? I've no idea. Are you sure a crime's happened? Absolutely. Well, in all probability, it probably has. Thank God the standard of evidence in criminal law is a damn sight higher. I guess these civil judges just kind of ask their opinion. What do you reckon? And they say, I don't know, yeah, maybe, probably. Seems like that to me. Article 25. However, I consider it more plausible than not. The limited private content complained about in the article was taken from the News of the World article. It is not the main focus of the Sunday Mirror article, which was the drunken activities alleged to have happened in Amica, which is a nightclub. And the breakup storyline appears to be super added on short notice. I accept the argument that an MGN journalist would even in such circumstances have tried to find out more or stand the story up independently, but there is no evidence that having been done so on this occasion, it seems very likely that there were attempts to cover the Duke's activities generally at this time, but that private information about his relationship was not obtained unlawfully on this occasion. So that would be a loss for Harry. You know what I mean? What's that first part again? It was published in the News of the World before it was in the Mirror. Again, I ask his legal counsel, what the hell were you doing with your research? Why? Why didn't you check? There is a thing called Google these days. I know some of these old articles might not be on it, but for God's sake, you're getting paid enough. Perhaps Sherborne should have a word with some of his people, make sure you do your research properly in future. Article 26. Although one can imagine that someone at the Mirror would have endeavoured to stand up to the story published over the previous weekend, there is nothing to support the Duke's case that details of the trial separation, that would be with Chelsea, were confirmed by voicemail interception or unlawful information gathering, and no new detail was published by the Mirror. In my judgment, this was likely to be another case of lazy journalism. I don't really know what he means by lazy journalism. I know what I mean by lazy journalism. Like, maybe a lot of the journalists have not read this judgment and they've just gone, Harry won, you know. Article 27. There's only 33, guys, so we're nearly there. In my judgment, information about the whereabouts of Miss Davy and the arrangements for her to spend the night in Kensington Palace are likely to have been obtained by voicemail interception. Miss Davy's arrival and departure were carefully observed and the photographer was not there by accident. The information about the state of the relationship and their sleeping arrangements, which were discovered by subterfuge, are clearly private and had not previously been put into the public domain. I don't know about that one, Fancourt, because I've seen photographers hang around at airports. I mean, they're there every day of the week, day and night, on the off chance of who they're going to get a photo of. And I would have thought entrances and exits from royal palaces may well, especially if they know there's trouble at Mill and Chelsea might be dumping Harry, or vice versa, or Harry's got a girlfriend. Article 28. There are no invoices or CRs, whatever the hell a CR is, credit report maybe, relating to this story. Nor is there any new content. This is another instance of lazy journalism to which no one was willing to put their name. So that'd be a loss for Harry. He loves his term lazy journalism. Article 29. In my judgment, given the involvement of Mr Harpin and Mr Palmer, and the absence of any explanation from a witness called by MGN, there is likely to have been voicemail interception or other unlawful information gathering involved in reporting this story. The story was not already in the public domain, though issues about the safety of the Duke serving in Afghanistan were. However, the fact that the Duke's non-deployment was not private to him, and further it was in the public interest to publish. That does not, however, extend to what is attributed to a source about the Duke's personal feelings, which is private information regarding his professional life about which complaint is made. Well, he's told he can't be deployed. That's in public interest. That's in the public domain. Again, I might be able to say, stating the bleeding obvious, that Harry would be pissed off about that his feelings would be bad about that. But I haven't had to intercept any voicemails to establish that. Believe me, Mr Fancourt, Or perhaps don't. Article 30. So we're nearly there. I reject the argument that this kind of detail about the nature of the breakdown and the feelings of those involved were not private, and that there was any proper public interest involved. So I guess that would be a win for Harry. Again, these are all to do with Chelsea. Article 31. In my judgment, this 3 a.m. article was just lazy journalism. Our spy was an invention, and no unlawful information gathering was involved in relation to the Duke's private information, which in any event could not include what happened in a hospitality box at a public event. Again, I say to David Sherborne's team, what are you thinking? And the final, oh no, we're not quite there, 32, Article 32, because the final one's really quite heartbreaking in a way. The information published about the first dinner party date and a possible romance was not trivial, as MGN argued. Even if there had been a previous publicity given to the relationship, that it was not trivial is evident from the trouble that those involved had taken. And the final one, so that'd be a win for Harry. The final one. In my judgment, the most probable explanation is that the people, the publication, the people, had obtained call data or accessed voicemails or both. So that would be a win for Harry. But the reason that last one is quite heartbreaking, well, for Meghan, and I can tell you how I would feel, is if you go into the judgment and you read that last article, it's all about how Chelsea dumped Harry, and he called her and bombarded her with texts and begged her that she was the love of his life, etc. And Harry has confirmed all of that happened because he's making allegations of how did the newspapers know it so accurately when they could actually have just guessed. But how is that going to make Meghan feel? So she wasn't first choice. Was it rebound? Well, not quite, because Cressida came in between, but then that's another matter, isn't it? I can imagine her being quite pissed off. Now, I know a lot of people will feel disappointed that Harry, on the balance of probabilities, won apparently on 15 points in these articles. But remind yourself who Harry and Meghan are. They are the Grand Duke and Duchess of planet Earth. Thou shalt worship them, thou shalt never disagree with them, thou shalt believe every word that they say, and they won't lie this at all. This is not good enough, Mr Fancourt, not good enough. And it certainly isn't for the Sugars, who are still going whoop whoop wild over on X, apparently accusing me of lying when I have gone to the trouble of writing down in my own handwriting, verbatim, exactly what the judge said, and I have put links in the description of all of the videos about what the judge says, and I would urge you to read them, because apart from anything else, I didn't know half the scandalous stuff about Harry that I do now, and he's come across and said, yeah, that's all true. There is some serious juice in that. I'm sorry this video's gone on a little bit longer, but I thought it was worth having a look at it, and I do wait for the day when mainstream media, any of them, start really scrutinising this and looking at it for what it is. And it will be interesting to know if the legacy media let us know anything about a costs hearing. As always, thank you very much for listening, and I will see you in the comments below.